first person to be executed in the year 2020 is John Gardner. John was born in Mississippi. He graduated from high school and worked as a painter prior to his arrest. John received an 8-year prison term in Mississippi for shooting his second wife, causing her to have a miscarriage and making her a paraplegic. Additionally, John threatened his third wife and eventually kidnapped her when she attempted to leave him. Police arrested John and returned him to prison. John Gardner married his second wife, Tammy, in 1999. According to those who knew her, after the marriage, Tammy lost weight, became introverted and lost her sparkle. Tammy had previously been known as very outgoing and happy. Gardner allegedly threatened and abused her. Shortly after marrying, Tammy sent her daughter to live with her father for her daughter's safety. Tammy had repeatedly told her friends and her boss that she was afraid for her life. She wanted out of her marriage, but feared Gardner would kill her if she left. In December 2004, Tammy borrowed money and filed for divorce, which was scheduled to become final on February 7, 2005. Friends and her daughter described how Tammy perked up after filing for divorce and kicking Gardner out of the house. Tammy also remained fearful, as Gardner continued to call and text her, leaving threatening messages. On January 23, 2005, Tammy was with her daughter when she began receiving text messages from Gardner, asking if she was going to go through with the upcoming divorce. Tammy did not answer. That evening Tammy visited with a co-worker, seeking help to disappear so that she could not be tracked. Tammy stayed with her co-worker for 3 hours, eventually returning home around 11 p.m., when she called her co-worker to say she arrived home. Just under an hour later, a 911 dispatcher with the Cline County Sheriff's Office received an emergency call from a woman identified as Tammy. Tammy requested an ambulance, saying she had been shot by her husband. When questioned further, Tammy said Stephen Gardner had shot her and then left in a white pickup truck with Mississippi plates. The dispatcher had difficulty understanding Tammy, as she was slurring her words and hard to hear. The dispatcher heard what sounded like choking and vomiting before the line disconnected. As police arrived, they noticed a white pickup not far from the house. Police knocked but received no response. When they were able to gain entry, police discovered Tammy sitting on the bed, with a trail of blood leading to the bathroom. She was bleeding badly from her head. Tammy was flown to Parkland Hospital and fell into a coma. After 2 days, she was taken off life support. She had been killed by a single gunshot to the head. Police discovered that Gardner had borrowed a white pickup from his brother-in-law and credit card purchases put him in Texas, near Tammy's house. Additionally, fibers were found in the truck that matched what Tammy was wearing. It was also discovered that someone had used a gun belonging to Gardner's sister. Gardner turned himself in to the police in Mississippi. John Stephen Gardner was executed at 6 p.m. local time on Wednesday, January 15, 2020, inside the Walls Unit of the Huntsville State Penitentiary in Huntsville, Texas. 64-year-old John is convicted of the murder of his wife, 41-year-old Tammy Gardner, on January 23, 2005. John has spent the last 13 years on death row in Texas.
The second person to be executed in the United States in 2020 was Donnie Cleveland Lance. A Georgia man convicted of killing his ex-wife and her boyfriend more than 2 decades ago was put to death Wednesday, becoming the state's first inmate executed this year. Donnie Cleveland Lance, 66, received a lethal injection at the state prison in Jackson and was pronounced dead at 9:05 p.m. January 29, 2020. The Georgia Attorney General's office said in a statement. Lance said nothing when he was given a chance to make a final statement and declined to have a chaplain say a prayer. Strapped to a gurney, he lay mostly still but wiggled his feet. The warden left the execution chamber at 8:54 p.m. January 29, 2020. Records from previous executions show that the lethal drug generally begins flowing within a minute or two of the warden's exit. Lance took about a dozen deep breaths and then became completely still about 3 minutes after the warden left. Lance had been sentenced to death for the killings of Sabrina, Joy, Lance and White Butch Wood Jr. The two were slain on November 8, 1997, at Wood's home in Jackson County, about 60 miles northeast of Atlanta. Lance went to the home, kicked in the front door and shot Wood in the front and back with a shotgun and then beat Joy Lance to death with the butt of the shotgun, according to a Georgia Supreme Court summary of the case. Lance had consistently said he did not kill the pair. Authorities have previously said there were no witnesses and that no murder weapon was ever found. Lance's lawyers have argued that no blood or other physical evidence linked him to the killings but that investigators focused only on him from the start. Lawyers for the state have argued in court filings that the evidence against Lance, although circumstantial, was overwhelming. Prosecutors had argued that Lance had long abused his ex-wife, both during their marriage and after their divorce, and had threatened multiple times to kill her. His lawyers wrote in a clemency application that the two had a troubled relationship and that alcohol abuse was a significant factor in a history of mutual aggression. Lance's lawyers have sought testing on various pieces of evidence, arguing that the testing could rule Lance out as the killer and could reveal the person responsible. In September, a judge declined a request for testing in a new trial. The judge said that in light of all the evidence presented at trial, it's unlikely the jury would have reached a different verdict if the results had been available. The Georgia Supreme Court declined to take the case. Separately, Lance's lawyers filed a petition last month in Butts County Superior Court alleging that the prosecutor improperly packed the grand jury with people he knew would side with him. Because the grand jury was not randomly selected, Lance's lawyers argued, the death sentence was invalid and unconstitutional. Lawyers for the state countered that those arguments have been previously raised and were rejected by the court. A judge agreed with the state and rejected the petition last week. The Georgia Supreme Court on Wednesday declined to hear an appeal or to stop Lance's execution, and his attorneys then unsuccessfully asked the U.S. Supreme Court to take up the case. The State Board of Pardons and Paroles held a closed-door hearing Tuesday and denied a defense request to spare Lance's life. The board is the only authority in Georgia with the power to commute a death sentence. In seeking clemency, Lance's lawyers had argued that Joy and Donnie Lance's now adult son and daughter already lost their mother and would suffer even more if their father was executed. We've spent our whole lives with this huge gaping hole in our hearts, but at least we've had that at our sides, Stephanie Landscape and Jesse Lance had written to the parole board. It's almost impossible to imagine that it could get worse. Prison officials said Lance received visits Wednesday from 15 family members, 1 friend and 3 attorneys. He was executed by lethal injection on the 29th of January 2020.
Capital punishment is a legal penalty in the U.S. state of Georgia. Georgia reintroduced the death penalty in 1973 after Furman v. Georgia ruled all states' death penalty statutes unconstitutional. The first execution to take place afterwards occurred in 1983. As of the 30th of January, 2020, 76 people in total have been executed since 1983. As of the 15th of April, 2020, 40 men and 1 woman are on death row awaiting execution. Kelly Renee Gisendana, the 8th of March, 1968, the 30th of September, 2015, was an American woman who was executed by the U.S. state of Georgia. Gisendana had been convicted of orchestrating the murder of her husband, Douglas Gisendana, the 14th of December, 1966, the 7th of February, 1997. At the time of the murder, Gisendana was 28 and her husband was 30. After her conviction, and until her execution, Gisendana was the only woman on death row in Georgia. Gisendana was born into a poor cotton farming family. According to sworn affidavits by friends and family members, she was molested by her stepfather and other men during her childhood and adolescence. During her senior year of high school, she claimed to have been date raped. 9 months later, her first son was born. In 1987, at the age of 19, Kelly Gisendana married her first husband Jeff Banks. They stayed together for 6 months. Kelly married Douglas Gisendana for the first time on the 2nd of September, 1989. They had a baby together, lost their jobs and moved in with Kelly's mother. Douglas joined the army and they were sent to Germany. Kelly got pregnant by another man who later died of cancer. She and Douglas were divorced in 1993. In May 1995, she remarried Douglas. In December 1996, the couple bought a house together in Auburn, Georgia. Kelly, in addition to her daughter with Douglas, had 2 sons. Douglas was the stepfather to her sons. On the 7th of February 1997, Gregory Bruce Owen, born the 17th of March 1971, hid near the couple's home in Auburn. When Douglas arrived, Owen forced Douglas into his car at knife point and drove him to a wooded area in Gwinnett County near Harbins Park. After striking Douglas in the head with a nightstick, Owen stabbed Douglas in the neck and back multiple times. When Kelly arrived at the scene moments later, the two set fire to her husband's car and hid the body in the woods. Before trial, prosecutors offered both Owen and Gisendana a plea deal of life in prison and no chance of parole for 25 years. Gisendana, however, rejected the plea deal. Gisendana was convicted of orchestrating her husband's murder and sentenced to death in 1998 after Owen testified against her in a plea agreement in which he was sentenced to life imprisonment. Owen told a jury that Gisendana had first approached him about a way to get rid of her husband 3 months before the murder. He further testified that Gisendana thought murder was the only way to get Douglas out of her life and still get the house and a payoff from his life insurance policy. During the trial, Gisendana was discovered to have threatened witnesses and also plotted to pay a witness to commit perjury. After being sentenced to death, Gisendana resided in Metro State Prison until it was closed in 2011. She was then transferred to Arendelle State Prison. While in prison, Gisendana had a conversion to Christianity. During her time in prison, Gisendana ministered to other women living in prison with her. A group of women who were incarcerated with Gisendana formed a group called the Struggle Sisters after they were released from prison. Gisendana spoke to the women through an air vent and prevented some from committing suicide, while other women tell of how Gisendana's words encouraged them to turn their lives around. the women released a video detailing the impact Gisendana had on their lives. In 2010, Gisendana enrolled in a theology studies program for prisoners, run by a consortium of Atlanta area divinity schools, including the Divinity School at Emory University. During theology studies, she became a student of Christian thinkers like Dietrich Bonhoeffer and Rowan Williams. Gisendana developed a relationship with Georgian Moldman while she was in prison. Gisendana sent Moldman a paper which she had written on Bonhoeffer. He was impressed with her paper, and he wrote back. After that, the two became pen pals, exchanging letters about theology and faith. Gisendana completed a theological degree program through Emory University. Gisendana's execution was scheduled for the 25th of February, 2015, then after a weather delay rescheduled for the 2nd of March, 2015, then further delayed when one of the execution drugs, pentobarbital, was thought to have been spoiled through improper storage, though it was later determined that the drug had rather merely precipitated out of solution due to colder than recommended storage conditions. Archbishop Carlo Maria Vigano, on behalf of Pope Francis, urged the Georgia State Board of Pardons and Paroles to spare Gisendana's life. Gisendana's clemency application to the Board of Pardons included support from a number of correctional officers whom she had met while in prison. Norman S. Fletcher, the former Chief Justice of the Supreme Court of Georgia, urged clemency because capital punishment was not proportional to her crime. The Georgia Republican Party's General Counsel and Republican Bob Barr also supported clemency. The board again declined to commute her sentence on the 29th of September, 2015. Georgia is one of 3 U.S. states in which the governor is not empowered to grant clemency to the condemned. Georgia Diagnostic and Classification State Prison, the execution site. Gisendana was scheduled to be executed on the 29th of September, 2015, but was again delayed by appeals. She was finally executed by lethal injection at the Georgia Diagnostic and Classification Prison in Jackson, Georgia, on the 30th of September at 12:21 a.m. Gisendana cried, prayed, sang Amazing Grace, and said, "Tell the Gisendana family, I am so sorry. That amazing man lost his life because of me, and if I could take it back, if this would change it, I would have done it a long time ago. But it's not. And I just hope they find peace, and I hope they find some happiness. God bless you." She was the first woman executed in Georgia since 1945, as well as the only woman executed in 2015, and also currently the last known woman to be executed in the United States. Thank you for watching Death Row. Please like and subscribe. Judy Buenoano, born Judy as Welty, also known as Judy as Goodyear and Judy as Morris, the 4th of April, 1943, was an American convicted murderer who was executed for the 1971 murder of her husband James Goodyear. She was also convicted for the 1980 murder of her son Michael Buenoano and of the 1983 attempted murder of her boyfriend John Gentry. Buenoano is also acknowledged to have been responsible for the 1978 death of her boyfriend Bobby Joe Morris in Colorado. However, by the time authorities made the connection between Buenoano and Morris, she had already been sentenced to death in the state of Florida. Buenoano is also believed to have been involved in a 1974 murder in Alabama, and in the 1980 death of her boyfriend Gerald Dossett. After her arrest, Dossett's body was exhumed and analyzed for signs of arsenic poisoning. No charges were laid in that case. Buenoano was the first woman to be executed in Florida since 1848. Judy Welty was married to James Goodyear, born the 7th of December, 1933. A sergeant in the U.S. Air Force, when he died on the 16th of September, 1971. His death was initially believed to be due to natural causes. In 1973, she moved in with Bobby Joe Morris, born 1939. Later that year, she legally changed her name to Buenoano, corrupted Spanish for Goodyear. In 1979, Buenoano's son Michael, the 30th of March, 1961, the 13th of May, 1980, became severely ill, with symptoms including paraplegia. On the 13th of May, 1980, Buenoano took Michael out in a canoe. The canoe rolled, and Michael, weighed down by his arm and leg braces, drowned. In 1983, Buenoano was in a relationship with John Gentry. Gentry was severely injured when his car exploded. While he was recovering from his injuries, police began to find several discrepancies in Buenoano's background. Further investigation revealed that, in November 1982, she had begun telling her friends that Gentry was suffering from a terminal illness. Vitamin pills which Buenoano had been giving Gentry contained arsenic and formaldehyde. Exhumations of Michael Goodyear, James Goodyear, and Bobby Joe Morris showed that all had died of arsenic poisoning. Buenoano received substantial life insurance after each death. In 1984, Buenoano was convicted for the murder of Michael and the attempted murder of Gentry. In 1985 she was convicted of the murder of James Goodyear. She received a 12-year sentence for the Gentry case, a life sentence for the Michael Buenoano case, and a death sentence for the James Goodyear case. She was convicted of multiple counts of grand theft, for insurance fraud, and is thought to have committed multiple acts of arson, again, for purposes of insurance fraud. All executions in Florida are carried out at the state penitentiary at Stark, and prior to 2000 all were carried out by electrocution in the state's 75-year-old electric chair. A total of 240 men and 1 woman have been put to death in the 3-legged chair, which was built by inmates in 1923. It was rebuilt in 1999 for the execution of Alan Lee Tiny Davis, who was considered to be too heavy for the old chair. Judy's last appeal was turned down on the 29th of March, 1998, and the then state governor Lawton Chiles duly signed her death warrant. She was transferred to Stark and confined to a 12 by 7-foot cell where she passed her time watching a small black and white television through the bars in the death watch area adjacent to the execution room. Judy spent her final hours seeing her adult children, Kim Hawkins and James Goodyear, other relatives and her legal and religious advisors. Jeannie Eaton, a cousin, who visited before the execution, was quoted as saying afterwards she had no fear at all, she's mostly afraid of leaving her children and how upset they were. In a television interview a few days before the execution, Judy said, "I would like to clear the record for my grandson. I would like for him to know that his grandmother was not a murderer." Execution was set for 7 a.m. on the Monday the 30th of March, 1998. At 4:30 a.m. she was showered and dressed, probably by female corrections, and her head shaved to give good electrical conductivity and so that her hair did not catch fire during the electrocution. Her final meal consisted of broccoli, asparagus, strawberries and hot tea. Judy entered the execution chamber at 7:02 a.m. accompanied by several guards. She was strapped into the large oak chair with 8 leather straps over her waist, wrists, chest and legs. The calf and headpiece electrodes were fitted, each containing moistened sponge to reduce burning of the flesh. Asked if she had a final statement, she replied, "No sir," squeezing her eyes shut and keeping them shut. not looking at the witnesses on the other side of a glass partition. A leather mask was placed over her face, and at the signal from the warden the automatic electrocution cycle commenced at 7:08 a.m. A small amount of white smoke, or steam, was seen to curl up from her right leg throughout the 38-second cycle, but there were no flames. She was pronounced dead at 7:13 a.m. In an interview afterwards, prison spokesman Jean Morris said, "She was very solemn. This is the first time I've seen that expression on her," he said. She stared straight ahead, made no visible expression. Judy's was the third of a series of 4 executions carried out in Florida over the period the 23rd of March, 1998 to the 31st of March, 1998. Her body was cremated. Thank you for watching, Death Row. Please like and A self-proclaimed white supremacist who tortured and killed an Arkansas family including an 8-year-old girl was executed on July 14, 2020. Daniel Lewis Lee, 47, was injected with a lethal dose of pentobarbital at 8:07 a.m., just hours after the Supreme Court greenlit the first federal execution to take place since 2003. He was wheeled into the execution chamber at the federal penitentiary in Terre Haute, Ind., strapped to a gurney, with more than half his body covered in a light blue blanket. 4 tubes were coming through a metal panel in the walls, and Lee breathed heavily before the drug was injected into his body, moving his legs and feet. He mumbled to himself briefly as his chest continued to rise and fall. At one point as the drug was being administered, he raised his head to look around. With his head cocked slightly to the left, his breathing appeared to become laboured. In a few moments, Lee's chest was no longer moving, his lips turned blue and his fingers became ashy. Daniel Lewis Lee was born the 13th of January, 1973, and he was executed on the 14th of July, 2020. Daniel was an American white supremacist and convicted murderer who was sentenced to death and executed for the murders of William Frederick Mueller, Nancy Ann Mueller, and their daughter Sarah Elizabeth Powell. Lee and his accomplice, Shivai, murdered the family at their home in Arkansas, on the 11th of January, 1996. Upon conviction, Lee was scheduled to be executed on the 13th of July, 2020, but on that date, a U.S. district judge blocked the execution, citing unresolved legal issues. Thereafter, on the 14th of July, the Supreme Court ruled that the execution could proceed. It was scheduled for 4 a.m. that same day. After another short delay, he was executed at 8:07 a.m. He was the first person executed by the U.S. federal government since 2003. Lee was born in Yukon, Oklahoma. He was reportedly abused and neglected as a child. On the 24th of July, 1990, in Oklahoma City, then 17-year-old Lee got into an altercation with another man, Joseph Joey Wavra III, at a party. Lee struck Wavra in the face and kicked him on the floor once he had collapsed. He then assisted his cousin, John David Patton, in moving Wavra to a sewer tunnel. Lee took items from Wavra and handed Patton a knife which Patton used to kill him. Lee then assisted in disposing of Wavra's clothes. On the 2nd of December, 1990, Lee pleaded guilty to robbery, whereupon the murder charge was dismissed. He was sentenced to 5 years imprisonment for his involvement in the crime, while Patton was sentenced to life without parole. Lee met white supremacist Shivai in 1995, and was recruited into a white supremacist organization known as the Aryan People's Republic or the Aryan People's Resistance, April. On the 3rd of May 1995, Lee was convicted of carrying a concealed weapon and was sentenced to 6 months probation. In January 1996, Lee and Kerr left the state of Washington and traveled to Arkansas. On the 11th of January 1996, they arrived at the home of William Frederick Mueller, a gun dealer who lived near Tilly, Arkansas, and who possessed a large collection of weapons, ammunition, and cash. Kerr and his father had robbed Mueller in February 1995, and Kerr expected to find valuable property at the house. Dressed in police raid clothing, the two men tried to enter the Mueller home, but the family was not at home. When the Muellers returned, Lee and Kerr overpowered and incapacitated Mueller and his wife, Nancy Ann Mueller, née Branch. They then questioned Nancy Mueller's 8-year-old daughter, Sarah Elizabeth Powell, about where they could find the cash, guns, and ammunition. After finding $50,000 in cash and gold, equivalent to $81,509 in 2019, and $30,000 worth of firearms and firearm parts, they shot each of the 3 victims with a stun gun. They then placed plastic bags over their heads, and sealed the bags with duct tape, suffocating them to death. They took the victims in Kerr's vehicle to the Illinois bayou, where they taped rocks to them and threw each family member into the swamp. For his part in the crime, Lee received $3,000 or $4,000 and a pistol. The bodies were discovered in Lake Dardanelle near Russellville, Arkansas, in late June 1996. Kerr and his family took the stolen property to a motel in Spokane, Washington, by way of the Christian Identity community of Elohim City, Oklahoma. On the 17th of June 1997, Kerr was arrested in Cedar City, Utah. When Kerr was sentenced to life imprisonment, local prosecutors planned to pursue a similar sentence of life imprisonment for accomplice Daniel Lewis Lee, but were directed by the United States Department of Justice in Washington, D.C. to argue for a death sentence. U.S. Attorney Paula Casey requested U.S. Attorney General Janet Reno withdraw jeopardy of capital punishment but was told by Deputy U.S. Attorney General Eric Holder to continue seeking a death sentence. Lee received a death sentence for 3 counts of murder in aid of racketeering. The mother of Nancy Mueller, Arlene Branch Peterson, pleaded for clemency on behalf of Lee. She stated, "I can't see how executing Daniel Lee will honor my daughter in any way. In fact, it's kinda like it dirties her name. Because she wouldn't want it and I don't want it." In December 1999, the United States Court of Appeals for the Eighth Circuit issued a writ of mandamus, quashing Lee's subpoenas of Reno and Holder regarding the sentencing decision. In March 2000, District Judge Garnet Thomas Eisel granted Lee's motion for a new penalty phase trial if the Attorney General herself decided not to withdraw the death penalty. In December 2001, that judgment was reversed by the Eighth Circuit, which reinstated Lee's death sentence. In July 2004, the Eighth Circuit affirmed Lee's conviction and death sentence on the merits. In April 2013, the Eighth Circuit affirmed the denial of Lee's habeas corpus petition challenging the constitutionality of his conviction. In July 2015, the Eighth Circuit affirmed the denial of Lee's subsequent habeas motion challenging the constitutionality of his prior habeas motion. Lee was scheduled to be executed on the 9th of December 2019, and would have been the first inmate to be executed by the federal government since the execution of Louis Jones Jr. in 2003. On the 20th of November 2019, U.S. District Judge Tanya Chutkan issued a preliminary injunction preventing the resumption of federal executions. Lee and the other three plaintiffs in the case argued that the use of pentobarbital may violate the Federal Death Penalty Act of 1994. On 5 December 2019, an Indiana federal court stayed Lee's execution, but the United States Court of Appeals for the Seventh Circuit vacated the Indiana federal court's stay of execution on 6 December 2019. Later that same day, the Supreme Court of the United States denied a stay of Chutkan's injunction against all federal executions while the U.S. Court of Appeals reviews Chutkan's decision. In April 2020, a panel of the United States Court of Appeals for the District of Columbia Circuit vacated District Judge Chutkan's injunction in a per curiam decision. Circuit Judges Gregory G. Katsas and Naomi Rao both wrote concurring opinions concluding that Lee may be executed, but for different reasons. Circuit Judge David Tatel dissented, arguing that the statute explicitly requires the federal government to follow state execution protocols. On 29 June 2020, the Supreme Court denied Lee's petition for a writ of certiorari, with Justices Ruth Bader Ginsburg and Sonia Sotomayor dissenting. The execution date was set for 13 July 2020, the first of several federal executions scheduled after the D.C. Circuit's ruling. The victims' families asked for a rescheduling of the date, saying they were unable to travel to witness the execution due to the COVID-19 pandemic in the United States, but the Seventh Circuit ruled that while allowing the victims' families to attend such events is standard practice, there are no rights or legal basis for their attendance, and denied a change in date. The victims' families sent an emergency appeal to the Supreme Court. Before the Supreme Court could rule, Judge Chutkan ordered a halt to all federal executions on the basis that the process was very likely to cause extreme pain and needless suffering. The Department of Justice appealed to both the Court of Appeals for the D.C. Circuit and the Supreme Court. The D.C. Circuit Court did not intervene. In the early morning of 14 July 2020, the Supreme Court lifted the hold that Judge Chutkan previously implemented in a 5-4 decision. This action allowed the Department of Justice to proceed with the execution. Lee's lawyers said that the execution could not go forward after midnight under federal regulations. Lee was executed later that morning. When asked for a final statement, he denied committing the crime, stating, "I didn't do it. I've made a lot of mistakes in my life, but I'm not a murderer. You're killing an innocent man," and that he and Kerr had been in a different part of the country when the crime occurred. Lee was pronounced dead at 8:07 a.m. after receiving a single-dose lethal injection of pentobarbital. Lee was the first person to be executed by the United States federal government since the execution of Louis Jones Jr. in 2003. Overall, his execution was the fourth federal execution since legislation permitting the resumption of the practice was passed in 1988. Thank you for watching Death Row. Please like and subscribe. Betty Lou Beets was born the 12th of March, 1937 and died the 24th of February, 2000. Betty was a murderer executed in the U.S. state of Texas. She was convicted of shooting her fifth husband, Jimmy Don Beets, on the 6th of August, 1983. Born Betty Lou Dunivant to Margaret Louise Smithwick, the 20th of April, 1917, the 16th of June, 1993, and James Garland Dunivant, the 15th of September, 1912, the 14th of February, 2003. She was born in Roxborough, North Carolina, on the 12th of March, 1937. Beats was hearing impaired due to a childhood bout with measles and claimed she was sexually abused by her father. When Beats was a child, the family moved from North Carolina to Hampton, Virginia, where her father was employed as a machinist at the Langley Research Center. Her mother was institutionalized when she was 12 years old, leaving her to take care of her younger sister and brother. Beats married her first husband, Robert Franklin Branson, at age 15, and according to her supporters, all of her marriages were plagued with sexual abuse and domestic violence, which Beats cited only well after her conviction and sentence of death. Beats had a criminal history prior to her arrest for murder, including public lewdness, and shooting former husband Bill Lane in the side of the stomach. Married 6 times, twice to the same man, Beats shot her second husband, Billy York Lane, twice in the back of the head in 1970. She was acquitted and the two remarried, divorcing again a month later. She later tried to run over her third husband, Ronnie C. Threlcott, with her car in 1978. Both men survived and testified at her murder trial. On 6 August 1983, Beats reported her husband missing from their home near Cedar Creek Lake in Henderson County, Texas. Her son, Robert Branson, would later testify that Beats had said that she intended to kill her husband and told her son to leave the house. On returning to the house 2 hours later, he found Jimmy Don Beats dead with 2 gunshot wounds. He helped his mother conceal the body in the front yard of the house, after which Beats telephoned the police. According to her son, Beats put some of Jimmy Don's heart medication in his fishing boat the next day. Branson and Beats then abandoned the boat in the lake. It was found on 12 August 1983, washed ashore near the Redwood Beach Marina. Believing that he had fallen overboard and drowned, the police spent 3 weeks dragging the lake, looking for Jimmy Don's body. In 1985, information was received by the Henderson County Sheriff that led to enough evidence to arrest Beats for the murder on June 8. A search warrant was issued and a search of Beats' home found the remains of Jimmy Don in a filled-in wishing well. Also found buried in a garage were the remains of Doyle Wayne Barker, another former husband of Beats. Both had been shot with a .38 caliber pistol. She was never tried for Barker's murder. Jimmy Don Beats was her 5th husband. She was sentenced to death by lethal injection. Her trial for the murder for remuneration and the promise of remuneration of Jimmy Don Beats began on the 11th of July 1985 in the 173rd District Court of Henderson County. She pleaded not guilty and claimed that 2 of her children had committed the murders. She was found guilty on the 11th of October. The evidence of abuse was never presented to the court. During the separate penalty phase 3 days later, she was sentenced to death. Beats was Texas Department of Criminal Justice, TDCJ, death row number 810. She was received by the Texas Department of Corrections on the 14th of October, 1985. She was incarcerated in the Mountain View Unit. An automatic appeal to the Texas Court of Criminal Appeals first overturned the conviction, saying that insurance and pension benefits were not the same as remuneration. The state requested a rehearing on the 21st of September, 1988, and this time the court ruled the conviction and sentence should stand. 10 years of appeals followed. The Supreme Court of the United States denied a writ on the 26th of June, 1989, and an execution date was set for November 8. On November 1, she received a stay from the trial court after she filed a state habeas petition. The Court of Criminal Appeals denied this request on the 27th of June, 1990, leading to a second execution date of December 6. A federal petition for a writ of habeas corpus was filed 3 days before her scheduled execution, and the federal district court granted a stay of execution on December 4. Throughout the first half of 1991, evidentiary hearings were held, and on May 9 the court granted relief on one of Beats's claims, but denied all others. The United States Court of Appeals upheld the decision on the 18th of March, 1993, but also overturned the one claim that had been granted relief. The case was sent to a federal district court, and on the 2nd of September, 1998, it denied her habeas corpus relief. After her appeals were denied throughout 1999, an execution date was set for the 24th of February, 2000. She was executed by lethal injection at 6:18 p.m. on the 24th of February, 2000 in the Huntsville unit. She did not request a final meal. Nor did she make a final statement. She was the second woman executed in the state after the reintroduction of the death penalty. At the time of the execution, she was 62 years old, and had 5 children, 9 grandchildren and 6 great-grandchildren. Like most executed criminals, she was cremated after her death. Her ashes were scattered over her mother's grave. Thank you for watching Death Row. Please like and subscribe.
Dustin Lee Honken was born March 22, 1968, and executed July 17, 2020. Angela Jane Johnson was born January 17, 1964. Were convicted of the 1993 murders of 5 people in Iowa. The victims were related to a drug trial against Honken. Honken was involved in the manufacturing of methamphetamine, and one of his dealers was set to testify against him. And so Honken and Johnson murdered him along with his girlfriend and her 2 daughters, aged 6 and 10. A few months later, the 5th victim, also a former dealer, was murdered. Dustin Honken was sentenced to death and executed by the federal government on July 17, 2020. The first defendant from Iowa to be executed since 1963. Angela Johnson was also sentenced to death, the first woman sentenced to death by a United States federal jury since the 1950s, but the sentence was overturned in 2012. And she was re-sentenced to life without parole in 2014. Honken and Johnson were a couple. Johnson had a child from a previous marriage and was pregnant by Honken at the time of the murders. Honken grew up in Britt. His father was an alcoholic and a bank robber. Honken had been a drug dealer and started cooking meth after studying chemistry at college. Johnson was born in Forest City, Iowa. In July 1993, Johnson posed as a saleswoman to get into the house of Honken's former drug dealer, who was set to testify against him. Honken forced him to record a statement of Honken's innocence. The informant was taken to the woods along with his girlfriend and her 2 daughters, where they were shot and buried. A few months later, the 5th victim, Terry DeJuice, was murdered. The victim was also a dealer for Honken and had previously dated Johnson. The victim was beaten with a bat and shot. Circuit Judge Roger Leyland Woolman, writing for the Unanimous Court of Appeals, described Johnson's participation thus: the killings resulted from her substantial participation in the murders. Namely, that she procured the murder weapon, participated in the hunt for Nicholson, employed a ruse so that she and Honken could gain entry to the Duncans' residence, bound and gagged at least one of the victims, and exploited her relationship with the Jews to lure him to the remote location where he was killed. Angela Johnson. In 2005, Johnson was found guilty of involvement in the murders, which had all been committed in Iowa. Capital punishment has been abolished in Iowa since 1965, but Johnson was charged under federal law because 3 of the victims were witnesses in a federal methamphetamine prosecution of Honkin. The jury that convicted her handed down 4 death sentences. The presiding judge stated, "I am troubled by the lack of certainty in the record concerning the precise involvement of Angela Johnson in these crimes." Under federal law, however, the judge is bound by the jury's verdict. In July 2007, the United States Court of Appeals for the Eighth Circuit upheld the conviction, finding sufficient evidence to conclude that Johnson had participated in the murders. On March 23, 2012, federal Judge Mark W. Bennett vacated Johnson's death sentence, citing a failure by her attorneys to introduce evidence about her mental state. The vacating of her death sentences did not affect her convictions in the case. Prosecutors did not pursue another death penalty sentence, so Johnson was resentenced to life without parole in December 2014. Federal authorities had stopped pursuing the death penalty for Johnson. Johnson, Federal Bureau of Prisons number 08337-029, is being held at Federal Correctional Institution, Waseca. Johnson's former boyfriend, Dustin Lee Honkin, was convicted of 5 counts of continuing criminal enterprise murder. Although it was Honkin who pulled the trigger, killing 3 adults and 2 children, Johnson received the death penalty for 4 of the victims, while Honkin was sentenced to death for only the 2 children. The unanimous Eighth Circuit affirmed Honkin's conviction and sentence in September 2008. On July 25, 2019, United States Attorney General William Barr approved the use of the single drug pentobarbital for federal executions, and an execution date of January 15, 2020, was set for Honkin. On November 20, 2019, U.S. District Judge U.S. Chutkan issued a preliminary injunction preventing the resumption of federal executions. Honkin and the other 3 plaintiffs in the case argued that the use of pentobarbital may violate the Federal Death Penalty Act of 1994. On December 5, 2019, the Supreme Court denied a stay of Chutkan's injunction, while the United States Court of Appeals for the District of Columbia Circuit reviewed Chutkan's decision. Honkin was imprisoned at the United States Penitentiary, TROUGH. While in prison, Honkin had converted to Catholicism. The Archbishop of Newark, Cardinal Joseph W. Tobin, had written to President Donald Trump in early July 2020 asking him to commute Honkin's sentence, claiming that he had witnessed Honkin's spiritual growth in faith and compassion. In April 2020, a divided panel of the D.C. Circuit vacated District Judge Chutkan's injunction in a per curiam decision. Circuit Judges Gregory G. Katsas and Naomi Rowe wrote concurring opinions concluding that Honkin may be executed, but for different reasons. Circuit Judge David Estatel dissented, arguing the statute explicitly requires the federal government to follow the state execution protocols. On June 29, 2020, the Supreme Court denied Honkin's petition for review, with Justices Ruth Bader Ginsburg and Sonia Sotomayor dissenting. On July 17, 2020, at 3:36 p.m. CST, Honkin was executed by lethal injection. His final words were, "Hail Mary, Mother of God, pray for me." Thank you for watching Death Row.
George Junius Stinney Jr. George was born on the 21st of October, 1929 and executed on the 16th of June, 1944. He was an African-American child who was convicted, in a proceeding later vacated as an unfair trial, of murdering two white girls, ages 7 and 11, in his hometown of Alcolu, South Carolina. He was executed by electric chair in June, 1944. Stinney is the youngest American to be sentenced to death and executed. A re-examination of the Stinney case began in 2004, and several individuals and Northeastern University School of Law sought a judicial review. His conviction was overturned in 2014, 70 years after he was executed, when a court ruled that he had not received a fair trial. In 1944, March 25, the bodies of two young girls, Betty June Buenoano was born 1933 and died 1944, age 11, and Mary Emma Thames, age 7, both white, were discovered in Alcolu, South Carolina. The girls had gone missing the day before, as they never returned home the previous night. Buenoano had died as the result of head trauma, her skull having been fractured. Police arrested 14-year-old George Stinney as a suspect. They stated that he had confessed to the crime while under custody. There was a written record of his confession in the form of notes provided by an investigating deputy. No transcript was recorded of the brief trial. Stinney was convicted of first-degree murder of the two girls in less than 10 minutes by an all-white jury, during a 2-hour trial. The court refused to hear his appeal. He was executed that year, still age 14, by electric chair. In the decades since Stinney's conviction and execution, the question of his guilt, the validity of his reported confession, and the judicial process leading to his execution have been extensively questioned. A group of lawyers and activists investigated the Stinney case on behalf of his family. In 2013, the family petitioned for a new trial. On the 17th of December, 2014, his conviction was posthumously vacated 70 years after his execution, because the circuit court judge ruled that he had not been given a fair trial, he had no effective defense representation, and his Sixth Amendment rights had been violated. The judgment noted that while Stinney could have committed the crime, the prosecution and trial were fundamentally flawed. Judge Mullen ruled that his confession was likely coerced and thus inadmissible. She also found that the execution of a 14-year-old constituted cruel and unusual punishment. In 1944, Stinney lived in Alcolu, South Carolina. The 14-year-old lived with his father, George Stinney Sr., mother Aim, brothers John, 17, and Charles, 12, and sisters Catherine, 10, and Aim, 7. George Sr. worked at the town's sawmill, and the family resided in company housing. Alcolu was a small, working-class mill town, where white and black neighborhoods were separated by railroad tracks. The town was typical of small southern towns of the time. Given segregated schools and churches for white and black residents, there was limited interaction between them. The bodies of Betty June Buenoano, age 11, and Mary Emma Thames, age 7, were found in a ditch on the 23rd of March, 1944, on the African American side of Alcolu, during a search after they had not returned home the night before. George Stinney Sr. helped in the search. The girls had been beaten with a weapon, variously reported as a piece of blunt metal or a railroad spike. The girls were last seen riding their bicycles looking for flowers. As they passed the Stinney's property, they had asked young George Stinney and his sister, Aim, if they knew where to find maypops, a local name for passion flowers. According to Aim, she was with George at the time the police later established for the murders. According to an article reported by the Wire Services on the 24th of March, 1944, and published widely, with the mistake of the boy's name preserved, the sheriff announced the arrest and said that George Junius had confessed and led officers to a hidden piece of iron. Both girls had suffered blunt force trauma to the face and head. Reports differed as to what kind of weapon had been used. According to a report by the medical examiner, these wounds had been inflicted by a blunt instrument with a round head, about the size of a hammer. Both girls' skulls were punctured. The medical examiner reported no evidence of sexual assault to the younger girl, though the genitalia of the older girl were slightly bruised. George Stinney and his older brother Johnny were arrested on suspicion of murdering the girls. Johnny was released by police, but George was held. He was not allowed to see his parents until after his trial and conviction. According to a handwritten statement, the arresting officer was H.S. Newman, a Clarendon County deputy, who stated, "I arrested a boy by the name of George Stinney. He then made a confession and told me where to find a piece of iron about 15 inches where he said he put it in a ditch about 6 feet from the bicycle." No confession statement signed by Stinney is known to exist. The 14-year-old claimed that the arresting officers starved him and then bribed him with food to confess. George was reported to have gotten into fights at school, including a fight where he scratched a girl with a knife. This assertion by Stinney's 7th-grade teacher, who was African American, was disputed by Ames Stinney Ruffner when it was reported in 1995. A local white woman who remembered Stinney from childhood said in 2014 that Stinney had threatened to kill her and her friend the day before the murder, and that he was known as a bully. Following George's arrest, his father was fired from his job at the local sawmill, and the Stinney family had to immediately vacate their company housing. The family feared for their safety. His parents did not see George again before the trial. He had no support during his 81-day confinement and trial. He was detained at a jail in Columbia 50 miles from Alcolu, due to the risk of lynching. Stinney was questioned alone, without his parents or an attorney. Although the Sixth Amendment guarantees legal counsel, it was not until 1963 Gideon v. Wainwright that explicitly required representation through the course of criminal proceedings. The entire proceeding against Stinney, including jury selection, took 1 day. Stinney's court-appointed defense counsel was Charles Plowden, a tax commissioner campaigning for election to local office. Plowden did not challenge the 3 police officers who testified that Stinney confessed to the 2 murders, despite this being the only evidence against him. He did not challenge the prosecution's presentation of 2 differing versions of Stinney's verbal confession. In one version, Stinney was attacked by the girls after he tried to help one girl who had fallen in the ditch, and he killed them in self-defense. In the other version, he had followed the girls, first attacking Mary Emma and then Betty June. There was no physical evidence linking him to the murders. There is no written record of Stinney's confession apart from Deputy Newman's statement. Stinney's trial had an all-white jury, as was typical at the time. As most black people were still disenfranchised and prohibited from voting, they could not be selected as jurors. More than 1,000 whites crowded the courtroom, but no black people were allowed. Other than the testimony of the 3 police officers, at trial prosecutors called 3 witnesses, Reverend Francis Batson, who discovered the bodies of the 2 girls, and the 2 doctors who performed the post-mortem examination. Conflicting confessions were reported to have been offered by the prosecution. The court allowed discussion of the possibility of rape, although the medical examiner's report had no evidence to support this. Stinney's counsel did not call any witnesses, did not cross-examine witnesses, and offered little or no defense. The trial presentation lasted 2.5 hours. The jury took less than 10 minutes to deliberate, after which they returned with a guilty verdict. Judge Philip H. Still sentenced Stinney to death by electrocution. There is no transcript of the trial. No appeal was filed by his defense attorney. Stinney's family, churches, and the NAACP appealed to Governor Olin D. Johnston for clemency, given the age of the boy. Others urged the governor to let the execution proceed, which he did. Johnston wrote in a response to one appeal for clemency. It may be interesting for you to know that Stinney killed the smaller girl to rape the larger one. Then he killed the larger girl and raped her dead body. 20 minutes later he returned and attempted to rape her again, but her body was too cold. All of this he admitted himself. Between the time of Stinney's arrest and his execution, Stinney's parents were allowed to see him once, after the trial when he was held in the Columbia Penitentiary. Under the threat of lynching, they were not allowed to see him any other time. Standing 5 feet 1 inch tall and weighing just over 90 kilo, George Stinney was executed at the Central Correctional Institution in Columbia, South Carolina on the 16th of June, 1944, at 7:30 p.m. He was prepared for execution by electric chair, using a Bible as a booster seat because George was too small for the chair. George was then restrained by his arms, legs, and body to the chair. The executioner placed the face mask over his face, which did not fit him. When the lethal electricity was applied, the mask covering George's face slipped off, revealing tears streaming down his face. He was buried in an unmarked grave in Sumter, South Carolina. In 2004, George Frierson, a local historian who grew up in Alcolu, started researching the case after reading a newspaper article about it. His work gained the attention of South Carolina lawyers Steve McKenzie and Matt Burgess. In addition, Ray Brown, attorney James Moon, and others contributed countless hours of research and review of historical documents, and found witnesses and evidence to assist in exonerating Stinney. Among those who aided the case were the Civil Rights and Restorative Justice Project, CRJ, at Northeastern University School of Law, which filed an amicus brief with the court in 2014. Frierson and the pro bono lawyers first sought relief through the Pardon and Parole Board of South Carolina. McKenzie and Burgess, along with attorney Ray Chandler representing Stinney's family, filed a motion for a new trial on the 25th of October, 2013. If we can get the case reopened, we can go to the judge and say, there wasn't any reason to convict this child. There was no evidence to present to the jury. There was no transcript. This case needs to be reopened. This is an injustice that needs to be righted. I'm pretty optimistic that if we can get the witnesses we need to come forward, we will be successful in court. We hopefully have a witness that's going to say that's non-family, non-relative witness who is going to be able to tie all this in and say that they were basically an alibi witness. They were there with Mr. Stinney and this did not occur. Steve McKenzie. George Frierson stated in interviews, there has been a person that has been named as being the culprit, who is now deceased. And it was said by the family that there was a deathbed confession. Frierson said that the rumored culprit came from a well-known, prominent white family. A member, or members, of that family had served on the initial coroner's inquest jury, which had recommended that Stinney be prosecuted. In its amicus brief, the CRJ said, there is compelling evidence that George Stinney was innocent of the crimes for which he was executed in 1944. The prosecutor relied, almost exclusively, on one piece of evidence to obtain a conviction in this capital case, the unrecorded, unsigned confession of a 14-year-old who was deprived of counsel and parental guidance, and whose defense lawyer shockingly failed to call exculpating witnesses or to preserve his right of appeal. New evidence in the court hearing in January 2014 included testimony by Stinney's siblings that he was with them at the time of the murders. In addition, an affidavit was introduced from the Reverend Francis Batson, who found the girls and pulled them from the water-filled ditch. In his statement he recalls there was not much blood in or around the ditch, suggesting that they may have been killed elsewhere and moved. Wilford Johnny Hunter, who was in prison with Stinney, testified that the teenager told him he had been made to confess and always maintained his innocence. The solicitor for the state of South Carolina, who argued for the state against exoneration, was Ernest Finney III. He is the son of Ernest Finney Jr., who was appointed as South Carolina's first African-American state Supreme Court justice since Reconstruction. Rather than approving a new trial, on the 17th of December, 2014, Circuit Court Judge Carmen Mullen vacated Stinney's conviction. She ruled that he had not received a fair trial, as he was not effectively defended and his Sixth Amendment right had been violated. The ruling was a rare use of the legal remedy of coram nobis. Judge Mullen ruled that his confession was likely coerced and thus inadmissible. She also found that the execution of a 14-year-old constituted cruel and unusual punishment, and that his attorney failed to call exculpating witnesses or to preserve his right of appeal. Mullen confined her judgment to the process of the prosecution, noting that Stinney may well have committed this crime. With reference to the legal process, Mullen wrote, "No one can justify a 14-year-old child charged, tried, convicted and executed in some 80 days, concluding that in essence, not much was done for this child when his life lay in the balance." Family members of both Betty Binnicker and Mary Thames expressed disappointment at the court's ruling. They said that although they acknowledge Stinney's execution at the age of 14 is controversial, they never doubted his guilt. The niece of Betty Binnicker claimed she and her family have extensively researched the case, and argues that people who just read these articles in the newspaper don't know the truth. Binnicker's niece alleges that, in the early 1990s, a police officer who had arrested Stinney had contacted her and said, "Don't you ever believe that boy didn't kill your aunt?" These family members said that the claims of a deathbed confession from an individual confessing to the girls' murders have never been substantiated. Thank you for The rate of executions has declined in recent years in Texas, as well. More than 36 people were executed in 2000, but in 2013, McCarthy was the 8th person subjected to capital punishment. Many Texans support the death penalty, according to a 2012 poll by the Texas Tribune and the University of Texas. Only 21% said they were opposed. Governor Rick Perry is among the majority. "I think our process works just fine," Perry said in 2012 during his unsuccessful presidential bid. "You may not agree with them, but we believe in our form of justice." Kimberly LaGale McCarthy was born the 11th of May, 1961 and died the 26th of June, 2013. Kimberly was a death row inmate who was convicted and sentenced to death for the 1997 murder of her neighbor, 71-year-old retired college professor Dorothy Booth, in her Lancaster, Texas home during a robbery. She was also a suspect in the murders of 2 other elderly Texas women, for which she was never tried. After her final federal appeal was denied in July 2012, her execution date was set for the 29th of January 2013. 2 reprieves pushed her execution date to the 26th of June 2013. McCarthy continued to proclaim her innocence, and stated that she was framed for murder. On the 26th of June, 2013, McCarthy was executed by the state of Texas by lethal injection, becoming the 500th person to be executed by the state of Texas using that method. She worked as an occupational therapist in a nursing home. She was briefly married to Aaron Michaels, with whom she had one son. During her adult life, she developed an addiction to crack cocaine. In 1990, she was convicted of forgery, and also had convictions for prostitution and theft of services. On the 21st of July, 1997, McCarthy reportedly called her neighbor, former El Centro College psychology professor Dorothy Booth, who was born the 14th of May, 1926 and died the 21st of July, 1997, saying that she was on her way over to borrow some sugar. Prosecutors later alleged that McCarthy's true intent was to rob Booth. After McCarthy arrived at Booth's home, she stabbed Booth 5 times with a butcher knife, beat her with a candelabrum, and cut off her finger to steal her diamond wedding ring. McCarthy then stole Booth's purse and Mercedes-Benz and pawned the diamond ring in order to buy crack cocaine. The day after Booth's murder, McCarthy was charged with murder. Evidence showed that McCarthy used Booth's credit cards at a liquor store and was in possession of Booth's driver's license. Booth's DNA was also found on the murder weapon, which police recovered from McCarthy's home. In 1998, McCarthy was convicted by a Dallas County, Texas jury of murdering Booth. During the sentencing hearing, prosecutors presented blood DNA evidence alleging that McCarthy also murdered 2 other elderly women in Dallas County in December 1988. 81-year-old Maggie Harding and 85-year-old Jetty Lucas, in order to purchase cocaine. McCarthy was never charged with those murders. On the 24th of November 1998, McCarthy was sentenced to die by lethal injection for killing Booth. McCarthy successfully appealed her conviction in 2002, but was later retried and resentenced to death on the 1st of November 2002. McCarthy's final federal appeal was denied in July 2012. Her attorneys sent a writ to the United States Supreme Court, and it was denied in January 2013. Her execution date was initially set for the 29th of January 2013. Only hours before her lethal injection was scheduled to occur, she was granted a stay of execution. Her execution was next set for the 3rd of April 2013. In late March, the Dallas County District Attorney announced that the date had been moved to the 26th of June 2013. McCarthy was executed by lethal injection at the Huntsville unit in Huntsville, Texas, on the 26th of June 2013. Her execution marked the 500th convicted killer to be executed by lethal injection in Texas, which averages 1 execution about every 4 weeks, since the death penalty resumed in the United States in 1976. She was 52 years old. She was pronounced dead at 6:37 p.m. CDT, 20 minutes after Texas prison officials began administering a single lethal dose of pentobarbital. McCarthy's last words were, "This is not a loss. This is a win. You know where I'm going. I'm going home to be with Jesus. Keep the faith. I love you all." She was the first woman executed in the United States in almost 3 years. Thank you for watching Death Row. Please like and subscribe. The The execution of Nathaniel Woods occurred on the 5th of March, 2020, at Atmore State Prison in Alabama, in what was described by many as a controversial execution due to questions about the reliability of Woods's conviction and sentence. The murder that Nathaniel Woods was convicted of took place on the 17th of June, 2004, in Birmingham, Alabama. 3 police officers unexpectedly came into the home of Nathaniel Woods and Kerry Spencer due to their home being a suspected drug house. Spencer had an SKS rifle when he heard the officers, while Woods was in the kitchen. Spencer came downstairs to see 2 officers pointing guns at him. Spencer fired shots at all 3 police officers, leading to their deaths. Woods ran out of the house when he heard the gunshots. Spencer and Woods were both charged with the murders, despite Woods never firing a weapon. Spencer claimed Woods was not involved and said, "Nate is absolutely innocent. That man didn't know I was going to shoot anybody, just like I didn't know I was going to shoot anybody that day, period." Days before Woods's execution, controversy started regarding Woods's sentence and whether he was genuinely guilty of the murders he was convicted of. Certain civil rights leaders, including Shaun King and Martin Luther King III, urged Alabama Governor Kay Ivey to commute his death sentence. Ivey told Woods's attorney that she denied his request for clemency. Kimberly Chisholm Simmons, the sister of one of the murdered officers, Harley Chisholm III, called Governor Ivey to request clemency for Woods and said, "He didn't kill my brother, and he didn't kill the other officers, may they rest in peace. I'm asking for mercy, and I believe my brother would want me to take a stance because of the man he was." Nathaniel Woods's execution by lethal injection began on the 5th of March, 2020 around 8:38 p.m., but Woods was not declared dead until approximately 9:01 p.m. Nathaniel Woods, 43, was executed on the 5th of March, 2020. Alabama Department of Corrections via AP. 10 minutes before Nathaniel Woods was scheduled to be executed for his role in the 2004 murder of 3 police officers, the Chief of Staff to the Governor of Alabama received a desperate phone call from the sister of one of the slain cops. Her plea: spare his life. "He didn't kill my brother, and he didn't kill the other officers, may they rest in peace." Kimberly Chisholm Simmons, the sister of murdered officer Harley Chisholm III, pleaded during the call that started around 5:50 p.m. on March the 5th. "I'm asking for mercy, and I believe my brother would want me to take a stance because of the man he was." Governor Kay Ivey's Chief of Staff, Joe Borner, said he would relay the message to other officials and suggested that Simmons should expect a call back. But the murder victim's sister never heard from another Alabama official, even after a temporary U.S. Supreme Court stay bought Woods a few more hours. Its justices ultimately elected not to intervene in his execution, and at 9:01 p.m., Woods, 43, died by lethal injection. The extraordinary 11th-hour phone conversation, which was recorded by Woods' attorney and shared with USA Today, has not been reported. The call was the result of back-channel negotiations in which Woods' attorney, Lauren Ferrano, was informed by sources connected to the highest levels of Alabama government within an hour of her client's scheduled execution that he could be spared if a victim's family member begged for his life. For those close to Woods, and undoubtedly the condemned man himself, the failed call for mercy was only one of several moments of emotional whiplash on the last day of his life. The prospect that Woods would be allowed to live was repeatedly held before them and then yanked away. The Supreme Court stay caused his family members to celebrate, believing he had been spared. His family learned within hours that his execution was still imminent. Woods' imam, who was set to witness his execution, said he was sent away from the prison and told he could return if the execution went ahead. But the imam was notified too late, and Woods was executed without his spiritual advisor present. Woods's case attracted national attention, including from high-profile supporters such as Martin Luther King III and Kim Kardashian, because of claims of police misconduct, flimsy evidence and poor representation in his 2005 trial. Prosecutors acknowledged that Woods didn't pull the trigger that ended the lives of the 3 police officers, instead convincing a jury that he had lured them into being killed by another man. The confessed shooter, Kerry Spencer, who is himself on death row, has said Woods was actually 100% innocent. It's unclear what steps Buono took, if any, after receiving the call from Simmons. He did not respond to an interview request for this story. His cell phone number that Simmons used that night, which Woods' own sister also said she subsequently called to beg for mercy, and that was then tweeted out to the world by King III, has since been disconnected. A spokeswoman for Ivy also declined to make the governor available, instead resending a statement she had issued the night of Woods' execution. "This is not a decision that I take lightly, but I firmly believe in the rule of law and that justice must be served," read the statement, adding that the governor's thoughts and most sincere prayers are for the families of the officers. May the God of all comfort be with these families as they continue to find peace and heal from this terrible crime. Not all of Chisholm's siblings feel the way his older sister Kimberly does about Woods's execution. At a news conference after the execution, members of Chisholm's family cheered the outcome. "One cop killer down as we patiently wait for the next one," said Starside Linker, sister to Harley and Kimberly. Ferrano, Woods' attorney, said her client's last hours alive, while his family hung on every development, were the cruelest moments I've ever been through in my life. Kimberly Chisholm Simmons and her brother Harley Chisholm III before his murder. Courtesy Kimberly Chisholm Simmons. Simmons' involvement in the final day of Woods' life started a few weeks earlier, when she received a letter at her home in Florida from authorities stating that Woods was set to be executed. Simmons hadn't closely followed the case since Woods' conviction, and she said the murder of her police officer brother, whom she called Buddy, had fractured her family. Although her sisters were eager for retribution, Simmons felt compelled to send an email to a non-profit death penalty website with the hope that it might reach Woods before he was put to death. "I forgive him for any involvement he had personally. I don't feel he's guilty as much as Spencer," Simmons wrote. "Only God knows the truth of what has really happened, and if it's in God's plan he will stay his execution. But I want him to know he is forgiven by me." The email was forwarded to Woods' attorney, Ferrano, the day before his scheduled execution. Ferrano makes her living in finance, and her pro bono legal work for Woods was a no-frills family affair. Her mother pooled legal files at the courthouse, and her stepfather, Bart Starr Jr., the son of a revered Alabama and Green Bay Packer quarterback and member of the Pro Football Hall of Fame, worked the phones with well-placed friends to lobby for mercy for the death row inmate. Starr Jr. was at Ferrano's Birmingham home with less than an hour to go before Woods' execution when one of those calls bore fruit. A prominent political donor told Starr his brother, an Alabama state senator, had conveyed that government officials might consider a stay if a victim's family member pleaded for it. Ferrano frantically emailed Simmons, "I am pleading with you, please give me a call." The victim's sister readily agreed to ask Alabama authorities to spare Woods' life. Ferrano's audio recorder caught the frenzied next hour. While Simmons waited on the other line, Ferrano dialed numbers to try to reach an Alabama official but found only switchboards and office voicemails. At about 5:45 p.m., roughly 15 minutes before Woods' scheduled execution, Ferrano heard Starr Jr. yell out, "What? Oh, no, 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 no," Ferrano said, weeping as she told Simmons, "I think they are executing him right now." But Buenoano's mother informed the lawyer it was actually good news. Supreme Court Justice Clarence Thomas had issued a temporary stay of execution. Simmons began celebrating. "God loves Nathaniel Woods," she said. Members of Woods' family learned of the stay from their cell phones and interpreted it as a lasting measure. Earlier that afternoon, Woods' 7 family members and his imam had joined him for what was supposed to be his last meal, and he had for the first time met his grandson. Now, his family and friends were overjoyed that it wouldn't also be the last time. "I'm shaking, I'm just so excited I don't know what to do, you know," family friend Jasmine Walters said moments after they learned of the stay. "I'm just so grateful. I'm so grateful." But Buenoano was aware that the Supreme Court's stay was only an interim step to allow the justices a couple of hours to decide whether to intervene, which was a long shot. Her efforts to reach an Alabama official before the stay might be lifted got a break when her stepfather ran to her office with Buonoano's cell phone number, obtained via a former University of Alabama football player. After Buonoano picked up, he declined to put Governor Ivey on the phone with Simmons, saying she was on another phone call. Simmons emphasized to Buonoano that all she was asking for was a renewed look at Woods' case. "I think they need to go over the evidence that they have brought forth," Simmons said. "I mean, it's not going to hurt nothing. I'm begging the courts," she added. "Please have mercy." Buonoano, a former congressman, responded dispassionately. "Have you communicated in writing this request?" he asked. Buonoano said that though he wasn't doubting Simmons was who she said she was, her identity may have to be verified. "Because of the severity of this, we have gotten calls from all over the country from people purporting to know things that they may or may not know." But Buonoano said he would convey Simmons' plea to the state attorney general and the governor's legal counsel. He took down her number and said representatives from those offices may give you a call to get some additional information. 2 hours passed with no Alabama official calling Simmons. At 8:06 p.m., the Supreme Court issued a one-sentence decision denying Woods' stay of execution, removing the only remaining obstacle to his death. Woods' sister, Pamela, said she also reached Buonoano on the cell phone number, asking to speak to the governor. "I begged, I screamed, I cried," Pamela Woods said. "He would not let me talk to her. He just said no. I begged him, screaming, 'Please, let me speak to her,' and he told me, no, and he hung up in my face." Simmons said she could tell during her conversation with Buonoano that it probably would have little effect. "I sensed, you know, you're not going to stop this, lady," she said. "They're going to take this man no matter what I say. It's already in their hearts to kill him." Nathaniel Woods with family members during his final visitation. Garcia Roberts, Gus. Nathaniel Woods's imam, Yusef Maisonette, said he was told to leave the prison after the Supreme Court stay and to expect an official to call him and escort him back in if the execution went forward that night. But the imam said nobody called him until shortly before Woods was returned to the execution chamber at close to 9 p.m. By then, thinking the execution was off, Maisonette had returned to his home in Mobile, more than 50 miles away. "I feel that they did purposefully keep me out of the prison for Woods' execution," Maisonette told USA Today last week. Samantha Rose, a spokeswoman for the Alabama Department of Corrections, disputed Maisonette's account. She said in a statement that after Maisonette was asked to wait in a certain area for the execution, he elected to leave this location on his own accord without speaking to security staff. When security staff arrived to take him to the execution, the imam was no longer on site. "We will not speculate on the reasons why this imam chose to leave when he did," Maisonette said he had spoken at length with Woods about topics including what he wanted done with his body. Before the day of the execution, Maisonette wrote to the Holman warden requesting that Wood's body not be autopsied since it is against our religious beliefs and the cause of death will be known. Alabama officials nonetheless performed the autopsy March 6, according to Buenoano. Alabama Corrections Department spokeswoman Rose said that decision was at the direction of Escambia County District Attorney Stephen Billy. Billy's office did not respond to a message seeking comment for this story. In a letter to Buenoano before the autopsy was completed, Billy said it was his policy to order autopsies on all executions, to confirm the cause and manner of death. It is not my intention of changing my position on this matter, Billy wrote to the lawyer, and would appreciate you not contacting my office again regarding this issue. Buenoano said she has not been informed of what the coroner found to be the official cause of Wood's death. Thank you for watching Death Row. Wanda Jean Allen was born the 17th of August, 1959 and died the 11th of January, 2001. She was sentenced to death in 1989 for the murder of Gloria Jean Leathers, 29, her longtime girlfriend. Allen was the first black woman to be executed in the United States since 1954. She was the sixth woman to be executed since executions resumed in Oklahoma in 1977. Her final appeals and the last 3 months of her life were chronicled by filmmaker Liz Garbus in the documentary The Execution of Wanda Jean, 2002. Wanda Jean Allen was the second of 8 children. Her mother was an alcoholic. Her father left home after Wanda's last sibling was born and the family lived in public housing and scraped by on public assistance. At the age of 12, Allen was hit by a truck and knocked unconscious, and at 14 or 15 she was stabbed in the left temple. It was found that Allen's actual abilities were markedly impaired and that her IQ was 69. Found particularly significant was that the left hemisphere of her brain was dysfunctional, impairing her comprehension, her ability to logically express herself, and her ability to analyze cause and effect relationships. It was also concluded that Allen was more chronically vulnerable than others to becoming disorganized by everyday stresses, and thus more vulnerable to a loss of control under stress. In 1981, Allen was sharing an apartment with Deidre Pettis, a childhood friend turned girlfriend. On the 29th of June, 1981, they got into an argument, and Allen shot and killed Pettis. In her 1981 confession, Allen stated that she accidentally shot Pettis from roughly 30 feet away while returning fire from Pettis' boyfriend. However, the forensic evidence was inconsistent with Allen's story. In particular, a police expert believed that bruises and powder burns on Pettis' body indicated that Allen had pistol whipped her, then shot her at point-blank range. Nevertheless, prosecutors cut a deal with Allen, and she received a 4-year sentence. In exchange for a guilty plea to a manslaughter charge. She served 2 years of the sentence. Pettis was buried at Trice Hill Cemetery in Oklahoma City, Oklahoma. By age 17, she had dropped out of high school. Of the 5 members of the Oklahoma Pardon and Parole Board, 3 were appointed by Governor Frank Keating. Keating, who considered giving Allen a stay based on the narrow issue of whether the Oklahoma Pardon and Parole Board had enough information regarding her education. Allen's attorneys have pointed to her score, a 69, on an IQ test she took in the 1970s, arguing she was in the range of intellectual disability. Prosecutors said Allen testified during the penalty phase of her trial that she had graduated from a high school and received a medical assistant certificate from a college. but they said Allen dropped out of high school at 16 and never finished coursework in the medical assistant program. 7 years after the death of Deirdre Pettis, Allen was living with her girlfriend Gloria Jean Leathers. The two met in prison and had a turbulent and violent relationship. On the 2nd of December, 1988, Leathers, 29, was shot in front of the village police department in Oklahoma City. 15 minutes before the shooting, the two women were involved in a dispute at a grocery store. A city officer escorted the two women to their house and stood by while Leathers collected her belongings. Leathers and her mother were on their way to file a complaint against Allen. When Leathers exited the car, Allen fired one shot, severely wounding Leathers in the abdomen. Leathers' mother witnessed the shooting. 2 police officers and a dispatcher heard the shot fired, but no police department employee witnessed the shooting. The police recovered a .38 caliber handgun they believe was used in the shooting near the women's home. Leathers died from the injury 3 days later, on the 5th of December, 1988. Leathers was buried at Green Acres Memorial Gardens Cemetery, Sperry in Tulsa County, Oklahoma. The state charged Allen with first-degree murder and announced that it would seek the death penalty. Evidence that Leathers had a history of violent conduct, and that she had stabbed a woman to death in Tulsa, Oklahoma in 1979, was central to the self-defense argument at Allen's trial. Allen testified that she feared Leathers because she had boasted to her about the killing. The defense sought to corroborate this claim with testimony from Leathers' mother, whom Leathers had told about the stabbing. However, the prosecution objected, and the court prohibited the introduction of such testimony because it was considered hearsay. The prosecutor depicted Allen as a remorseless liar. The jury found her guilty of first-degree murder and sentenced her to death. During the punishment phase, the prosecutors argued that Allen should be sentenced to death because she had been previously convicted of a felony involving the use or threat of violence, that she was a continuing threat to society, and she committed the murder to avoid arrest or prosecution. The jury found that the first 2 aggravating circumstances existed in Allen's case. Her defense presented numerous mitigating circumstances including good relationship with her family, good work habits, and her fear of the victim. In the sentencing phase, the prosecution presented testimony on the circumstances of the death of Deirdre Pettis, and compared this previous crime to the death of Leathers. In a 1991 affidavit, her defense lawyer David Presson stated that after the trial he learned that when Allen was 15 years old, her IQ was measured at 69, placing her just within the upper limit of the classification of mental retardation according to the psychologist who analyzed her, and that an examining doctor had recommended a neurological assessment, because she manifested symptoms of brain damage. The lawyer stated, "I did not search for any medical or psychological records or seek expert assistance for use at the trial." A psychologist conducted a comprehensive evaluation of Allen in 1995 and found clear and convincing evidence of cognitive and sensorimotor deficits and brain dysfunction possibly linked to an adolescent head injury. Allen spent 12 years on death row. Her application for clemency was denied. While in prison, she became a born-again Christian. The Reverend Robin Mayers, who served as a spiritual advisor to Allen, is quoted as saying, "I always suspected that Wanda's renunciation of lesbianism had more to do with helping to revamp herself in the most palatable way for her clemency and appeal processes. She knew perfectly well that her being a lesbian was a big strike against her and that it's an embarrassment in the black community. She was going to play the best hand that she could play at the very end." Allen, then 41, was executed by lethal injection by the state of Oklahoma on Thursday, the 11th of January 2001 at Oklahoma State Penitentiary in McAlester. 24 relatives of murder victim Gloria Leathers and manslaughter victim Deirdre Pettis traveled there for the execution. Many of them watched the execution from behind a tinted window. While lying on the execution gurney, Allen said, "Father, forgive them. They know not what they do." She also stuck her tongue out and smiled at her appeal lawyer, Steve Presson, who had become her friend. He says she was dancing on the mattress, while they tried to kill her. She was pronounced dead at 9:21 p.m. Relatives of Leathers expressed the execution gave them closure. She was buried at Trice Hill Cemetery in Oklahoma City. Thank you for watching Death Row. Christopher J. Newton was born the 13th of November, 1969 and died the 24th of May, 2007, was an American murderer executed in the state of Ohio in 2007. Christopher Newton received the death penalty for the 2001 aggravated murder of his cellmate, Jason Brewer. At the time of the murder, Newton was imprisoned for attempted aggravated burglary of his father's home, an offense he committed a few weeks after his release from prison for a prior attempted aggravated burglary. Newton killed Brewer in their cell by stomping on his neck and head and strangling him with a strip of cloth. According to the opinion of the Ohio Supreme Court affirming the death penalty, Newton laughed while responding. Officials tried to resuscitate Brewer, having smeared Brewer's blood on his face and drunk some of it, stating, "If he is not dead, I hope he is going to be a vegetable." Newton admitted that another inmate had hired him to assault Brewer, and that he was ready to die in prison and knew that murdering another inmate would warrant the death penalty. According to the Ohio Supreme Court, numerous psychiatrists and psychologists had examined Newton over the years, resulting in various diagnoses. At the capital trial, a defense psychologist testified that Newton had several mental health disorders, including mood disorder and symptoms of PTSD. In response, a government psychiatrist reviewed the mental health history and rebutted the defense expert. The court denied defense funds for neuropsychiatric tests to explore other types of mental disability. The trial was before a three-court panel of judges who, after hearing the evidence, imposed the death penalty. A controversy arose regarding the delay in Newton's execution, as at the time he weighed 265 pounds, 120 kilograms. Subsequently, his veins were very difficult to locate, which made administration of the injections difficult. It took over 2 hours and 10 attempts before the execution was completed. The problems with Newton's execution occurred 1 year after the 90-minute execution of fellow Ohio inmate, Joseph Lewis Clark. The execution by injection of Christopher Newton on Thursday took nearly 2 hours, longer than any since Ohio reinstated the death penalty in 1999. Here is a timeline of the procedure, which begins with a shunt being placed in each of the inmate's arms, compiled from the prison log and a reporter's observations from the witness viewing area. 10:03 a.m. Execution team visible on witness area TV screen beginning work on Newton. 10:10 a.m. After unsuccessfully trying insertion points on both arms, technicians begin exploring the upper and lower portions of Newton's arms, inner and outer elbows, wrists, and hands, as well as his right leg, tapping and massaging in their attempts to find spots to insert the shunts. He was stuck with needles at least 10 times. 10:27 a.m., 4 is inserted in left arm. Medical staff continues working on right arm. 10:56 a.m., in the viewing chamber, where witnesses are discouraged from talking, prison's spokeswoman Andrea Dean holds up a note to reporters, "We have told the team to take their time." His size is creating a problem. 10:58 a.m., medical team exits chamber for 2 minutes. 11:03 a.m., preparations reach the 1-hour mark. 11:05 a.m., Newton is given a 2-minute bathroom break. 11:28 a.m., 4 inserted in right arm. 11:33 a.m., Newton walks from the medical chamber into the death chamber. He is visible to witnesses through a glass partition. 11:36 a.m., strapped to the gurney with lines now attached, Newton delivers his final statement into a microphone. He talks and laughs with 2 attending officials, inaudible to witnesses, for another 3 minutes. 11:37 a.m., signal given for chemicals to begin flowing. 11:39 a.m., Newton's eyes close. 11:40 a.m., Newton's belly begins to heave, his chin and face shudder and twitch, and his body twice mildly convulses on the table within his restraints. 11:45 a.m., movements stop. 11:51 a.m., curtain between witnesses and death chamber is pulled for coroner examination. 11:53 a.m., Newton declared dead. Christopher Newton was the 19th person put to death in the United States in 2007. The 1077. Since the United States restored executions in 1976. Andrea Dean, spokeswoman for the Ohio Department of Corrections, said Newton was obese and staff had been told in advance to take as much time as needed to locate the proper sites for the injection. Ohio had a problem with lethal injection in 2006 after a condemned man's vein collapsed and he woke up telling his executioners the drugs were not working. After finding another vein, that execution was completed. Lethal injection, by far the most common method of execution in the United States, has been under attack as cruel and unusual punishment, amid claims that the condemned may suffer excruciating pain. Newton's last words were, "I sure could use a beef stew and a chicken bone." He had waived all appeals and said he wanted to die. Newton was serving a sentence for burglary and parole violation in 2001 when he beat and strangled his cellmate, Scott Brewer, after an argument. Given a meal of his choosing on Wednesday night, Newton was served steak, asparagus, Brussels sprouts, feta cheese, a soft drink, cake and watermelon. It took so long to hook up Christopher J. Newton's lethal injection for that the condemned man had to ask for a bathroom break. For 90 minutes, from about 10 to 11:30 a.m., paramedics working in cramped quarters in the death house at the Southern Ohio Correctional Facility struggled to tap veins with intravenous lines so that Newton could be put to death. Finally, the lines were secured and the deadly chemicals did their job. Newton, 37 years, was declared dead at 11:53 a.m. Prison officials said the lengthy delay, the longest since Ohio resumed capital punishment in 1999, was attributable to Newton's size. At 6 feet tall and 265 pounds, Newton was obese and had deeply buried veins. At one point, Newton asked and was permitted to use the restroom for 2 minutes before paramedics went back to work. Eventually, they secured sights in both arms. The previous longest delay, 1 hour, came during the execution of Joseph Clark on May 2 last year. Paramedics attached a single fore to Clark's arm, but when the vein collapsed, Clark tried to rise off the table and said several times, "It don't work." Through it all, Newton smiled, joked with prison personnel and did what a witness described as belly laughs on the lethal injection table. A high school dropout from Huron, Ohio, who began his life of crime by stealing candy bars as a boy, Newton was executed for killing his cellmate, Jason Brewer, 27. Newton beat and strangled Brewer, whom he outweighed by 100 pounds, on the 15th of November, 2001, after they argued over a chess game. Newton, who had a history of mental health problems, said he was mad because Brewer kept giving up before the chess game was over. The American Civil Liberties Union of Ohio released a statement yesterday urging a swift halt to capital punishment in Ohio because of problems with the Newton and Clark cases. Having one botched execution is too many. That Ohio has now had 2 botched executions in 1 year is intolerable, the ACLU said. Likewise, Ohio to stop executions called it inhumane treatment and urged Governor Ted Strickland to stop all executions. In an interview, Strickland told the Dispatch that he was personally satisfied that everything that was done during that process showed consideration for the inmate. He said the event is not a justification for a change of position regarding the death penalty in Ohio. Strickland, who monitored the execution from his state house office, added, "It's a sad and tragic thing when any human life is lost." Terry Collins, director of the Department of Rehabilitation and Correction, said the 4 problems were handled in line with procedural changes he made after Clark's execution. "We told them, take your time, be comfortable, and do your job," Collins said. Dr. Jonathan Groner, trauma medical director at Children's Hospital and a longtime critic of execution procedures, said the lengthy process equated to torturing someone to death with needles. From a human rights perspective, it's not acceptable. Newton's last words, "Boy, I could sure go for some beef stew and a chicken bone," were apparently a message to friends on death row, officials said. Robert K. Lowe, Newton's public defender attorney, later read a statement from his client in which Newton apologized to Brewer. Christopher J. Newton was born the 13th of November, 1969 and died the 24th of May, 2007, was an American murderer executed in the state of Ohio in 2007. Christopher Newton received the death penalty for the 2001 aggravated murder of his cellmate, Jason Brewer. At the time of the murder, Newton was imprisoned for attempted aggravated burglary of his father's home, an offense he committed a few weeks after his release from prison for a prior attempted aggravated burglary. Newton killed Brewer in their cell by stomping on his neck and head and strangling him with a strip of cloth. According to the opinion of the Ohio Supreme Court affirming the death penalty, Newton laughed while responding. Officials tried to resuscitate Brewer, having smeared Brewer's blood on his face and drunk some of it, stating, "If he is not dead, I hope he is going to be a vegetable." Newton admitted that another inmate had hired him to assault Brewer, and that he was ready to die in prison and knew that murdering another inmate would warrant the death penalty. According to the Ohio Supreme Court, numerous psychiatrists and psychologists had examined Newton over the years, resulting in various diagnoses. At the capital trial, a defense psychologist testified that Newton had several mental health disorders, including mood disorder and symptoms of PTSD. In response, a government psychiatrist reviewed the mental health history and rebutted the defense expert. The court denied defense funds for neuropsychiatric tests to explore other types of mental disability. The trial was before a 3-court panel of judges who, after hearing the evidence, imposed the death penalty. A controversy arose regarding the delay in Newton's execution, as at the time he weighed 265 pounds, 120 kilograms. Subsequently, his veins were very difficult to locate, which made administration of the injections difficult. It took over 2 hours and 10 attempts before the execution was completed. The problems with Newton's execution occurred 1 year after the 90-minute execution of fellow Ohio inmate, Joseph Lewis Clark. The execution by injection of Christopher Newton on Thursday took nearly 2 hours, longer than any since Ohio reinstated the death penalty in 1999. Here is a timeline of the procedure, which begins with a shunt being placed in each of the inmate's arms, compiled from the prison log and a reporter's observations from the witness viewing area. 10:03 a.m. Execution team visible on witness area TV screen beginning work on Newton. 10:10 a.m. After unsuccessfully trying insertion points on both arms, technicians begin exploring the upper and lower portions of Newton's arms, inner and outer elbows, wrists, and hands, as well as his right leg, tapping and massaging in their attempts to find spots to insert the shunts. He was stuck with needles at least 10 times. 10:27 a.m. 4 is inserted in left arm. Medical staff continues working on right arm. 10:56 a.m. In the viewing chamber, where witnesses are discouraged from talking, prison's spokeswoman Andrea Dean holds up a note to reporters: "We have told the team to take their time. His size is creating a problem." 10:58 a.m. Medical team exits chamber for 2 minutes. 11:03 a.m. Preparations reach the 1-hour mark. 11:05 a.m. Newton is given a 2-minute bathroom break. 11:28 a.m. 4 inserted in right arm. 11:33 a.m. Newton walks from the medical chamber into the death chamber. He is visible to witnesses through a glass partition. 11:36 a.m. Strapped to the gurney with lines now attached, Newton delivers his final statement into a microphone. He talks and laughs with 2 attending officials, inaudible to witnesses, for another 3 minutes. 11:37 a.m. Signal given for chemicals to begin flowing. 11:39 a.m. Newton's eyes close. 11:40 a.m. Newton's belly begins to heave, his chin and face shudder and twitch, and his body twice mildly convulses on the table within his restraints. 11:45 a.m. Movements stop. 11:51 a.m. Curtain between witnesses and death chamber is pulled for coroner examination. 11:53 a.m. Newton declared dead. Christopher Newton was the 19th person put to death in the United States in 2007. The 1077. Since the United States restored executions in 1976. Andrea Dean, spokeswoman for the Ohio Department of Corrections, said Newton was obese and staff had been told in advance to take as much time as needed to locate the proper sites for the injection. Ohio had a problem with lethal injection in 2006 after a condemned man's vein collapsed and he woke up telling his executioners the drugs were not working. After finding another vein, that execution was completed. Lethal injection, by far the most common method of execution in the United States, has been under attack as cruel and unusual punishment, amid claims that the condemned may suffer excruciating pain. Newton's last words were, "I sure could use a beef stew and a chicken bone." He had waived all appeals and said he wanted to die. Newton was serving a sentence for burglary and parole violation in 2001 when he beat and strangled his cellmate, Scott Brewer, after an argument. Given a meal of his choosing on Wednesday night, Newton was served steak, asparagus, Brussels sprouts, feta cheese, a soft drink, cake and watermelon. It took so long to hook up Christopher J. Newton's lethal injection for that the condemned man had to ask for a bathroom break. For 90 minutes, from about 10 to 11:30 a.m., paramedics working in cramped quarters in the death house at the Southern Ohio Correctional Facility struggled to tap veins with intravenous lines so that Newton could be put to death. Finally, the lines were secured and the deadly chemicals did their job. Newton, 37 years, was declared dead at 11:53 a.m. Prison officials said the lengthy delay, the longest since Ohio resumed capital punishment in 1999, was attributable to Newton's size. At 6 feet tall and 265 pounds, Newton was obese and had deeply buried veins. At one point, Newton asked and was permitted to use the restroom for 2 minutes before paramedics went back to work. Eventually, they secured sights in both arms. The previous longest delay, 1 hour, came during the execution of Joseph Clark on May 2 last year. Paramedics attached a single fore to Clark's arm, but when the vein collapsed, Clark tried to rise off the table and said several times, "It don't work." Through it all, Newton smiled, joked with prison personnel and did what a witness described as belly laughs on the lethal injection table. A high school dropout from Huron, Ohio, who began his life of crime by stealing candy bars as a boy, Newton was executed for killing his cellmate, Jason Brewer, 27. Newton beat and strangled Brewer, whom he outweighed by 100 pounds, on 15 November, 2001, after they argued over a chess game. Newton, who had a history of mental health problems, said he was mad because Brewer kept giving up before the chess game was over. The American Civil Liberties Union of Ohio released a statement yesterday urging a swift halt to capital punishment in Ohio because of problems with the Newton and Clark cases. Having one botched execution is too many. That Ohio has now had 2 botched executions in 1 year is intolerable, the ACLU said. Likewise, Ohio to stop executions called it inhumane treatment and urged Governor Ted Strickland to stop all executions. In an interview, Strickland told the Dispatch that he was personally satisfied that everything that was done during that process showed consideration for the inmate. He said the event is not a justification for a change of position regarding the death penalty in Ohio. Strickland, who monitored the execution from his state house office, added, "It's a sad and tragic thing when any human life is lost." Terry Collins, director of the Department of Rehabilitation and Correction, said the 4 problems were handled in line with procedural changes he made after Clark's execution. "We told them, take your time, be comfortable, and do your job," Collins said. Dr. Jonathan Groner, trauma medical director at Children's Hospital and a longtime critic of execution procedures, said the lengthy process equated to torturing someone to death with needles. From a human rights perspective, it's not acceptable. Newton's last words, "Boy, I could sure go for some beef stew and a chicken bone," were apparently a message to friends on death row, officials said. Robert K. Lowe, Newton's public defender attorney, later read a statement from his client in which Newton apologized to Brewer.